Good morning. Today I'm going to discuss, as an introductory matter, the history and nature of equity. And when we look at this topic, we've got to look at things historically, unfortunately, because the law of equity developed over many, many centuries, which means that the law which you look at today has engrafted on it a large number of historical anomalies, I suppose. The common law doesn't develop empirically, as we all know. No code, we simply develop as time goes by. So what is equity? Well, modern equity derives from a very broad jurisdiction which was originally exercised by the Lord Chancellor in England. And the Lord Chancellor historically was the King's Secretary and had in his possession the Great Seal of England. And we're looking now many centuries back, but the Lord Chancellor began to exercise his own particular jurisdiction by issuing orders under the seal and in his own name to supplement or complement the common law. And if you think back to your legal history, the common law began and still operates under a series of writs. A writ is a command by the king to turn up and answer a particular complaint, but the writs became very formulaic very early on. That's to say, they became quite ossified. The range of relief you could get depended very much on finding a particular appropriate writ. The Lord Chancellor, of course, was acting on his own behalf really when he started, and he had a much more flexible range of remedies available to him. And when we consider equity, we've got to note two important things right at the beginning. First of all equitable remedies are discretionary. That's to say, they depend upon the discretion of the court. The court may or may not refuse relief depending on particular circumstances. And secondly, equity, as we say, acts in personam. That's to say, equity acts on the particular individual defendant. It orders him or her to do something or to stop doing something. If you think back to your torts days, the courts, in relation to common law, of course, issue a writ, but that writ entitles you to often damages, for example, as of right. You're entitled to receive even nominal damages for a breach of contract or for some tort. That's not the case in equity. There's nothing given to you as of right, and that's a fundamental thing to grasp right from the beginning. Equity is looking at a matter of discretion, and it's looking at acting personally. So, the Lord Chancellor had the power, we don't need to worry about the history of it, to order the plaintiff personally to do something which, in good conscience, he was required to do, upon pain of imprisonment for contempt if the command were not obeyed. So we're looking at something which the plaintiff does personally, and the last point I just added is very important. In the old days, the Lord Chancellor, if you remember some of the films you've watched, was always a priest, a Catholic priest, in fact, in the very old days. And so equity was informed right from the beginning by notions of conscience. What is good conscience? What's unconscientious behaviour? What's unconscionable conduct? All those things derive at base from some notion of Christian ethics, what good conscience and good behaviour requires. Right, so we've got that as a starting point. And to repeat, we've got equity acting personally as a matter of discretion and acting on the conscience of the particular party who is affected. Now, just as a sidelight, as you may already know, from the very beginning, the courts of equity developed the notion of a trust. And a trust is unique to the English legal system. Continental systems and civil law systems don't have a trust. What is a trust? Well, a trust arises when a settlor settles property on a trust to be held by a trustee for the benefit of beneficiaries. And sometimes you'll see a beneficiary in the old books described as a settee trust, C-E-S-T-U-I, new word Q-U-E, new word T-R-U-S-T. That's law French. And it's funny to remember now, but until about 1603, French was the official language of the courts in England. So with the very old cases, we get some law French mixed up with it, which is a bit like modern French, but it takes a bit of study to look at it. And so the courts of equity developed that notion of a trust by requiring the person who had undertaken to hold the property to do so on behalf of somebody else and look after them. Well, how did that notion arise? Well, it arose because of the feudal system. If you recall, under the feudal system, as a matter of property law, everyone was holding via someone else up the ladder to the king, who was the paramount overlord. The king's in command. And the king required certain feudal penalties and duties to be paid. If you were a knight, you had to turn up with a few troops. If you were something a bit lower, you had something less to do. But basically, up and down the food chain, the supply chain, you had to perform various feudal services. Secondly, if property was lost, then property would escheat, E-S-C-H-E-A-T. It would pass up the line, notionally up to the king. So, in the bad old days, of course, things were a bit rockier than they are now. If you're attainted for treason, you're beheaded or whatever, then you might lose all your property. But, of course, if it was being held by a trust or in some religious organisation on trust, then that could not happen. So it became attractive over the years for property law to start using the trust as a very flexible instrument to hold property and protect interests. And the Court of Chancery, the Equity Court, developed that whole notion as it went forward. So we've got the notion of a trust, we've got the notion of a trust being a protective device initially, and we've also got the notion of a trust being a very flexible means of holding property. Because what happens in a trust essentially is that we're separating the legal and the equitable ownership. The legal ownership stays with the trustee, the equitable ownership passes and is available to the beneficiaries, who have a right to enforce the trust against the trustee. That's the essence of it, pretty simple. It gets a bit more complex, but we'll discuss those complexities in due course. So, under a feudal system, that sort of operation had large practical benefits. It permitted you essentially to avoid certain feudal duties and obligations which might have fallen upon you as the legal owner, and it also prevented an escheat to the king in the event of treason. Well, land, of course, in the old days was held very closely indeed. The feudal system meant that there were only about 150 families involved in the running of the country. Everyone else, my ancestors, I suppose, out there in Scotland, were all at the bottom of the food chain, grafting away, doing something or other. But above them were all the earls, the barons, the viscounts. They were all the powerful operators. They held virtually the entirety of England under their own control. And English history really is a series of wars and fighting between various families, if you think about it, for upwards of 300 or 400 years. So, trusts, of course, still play a very large and important part in the holding of land and property. And as English law developed, the law became more and more complex with respect to property law and trusts. If you want a good example of that, just think of Pride and Prejudice. Mr. Bennet, of course, has got daughters and only daughters. Why is that important? Well, it's important because the way in which the land was held through an entail meant that it had to pass as a matter of property law only to a male descendant of the original settler of the property, not to any female. So a problem there for Mr. Bennet. That's just a good example. You can think of lots of English literature which is based on a problem involving land law and some variety of trusts. So, just to summarise, if we look at it from a common law perspective, of course, there was a large amount of discretion being built into things, which was always a feature of equity, the Court of Equity. And a famous the common lawyer, John Selden, a famous book called Table Talk in about 1700, said that the problem with equity was that the rules of equity varied with the length of the Chancellor's foot. In other words, whichever Chancellor you had a bigger or smaller foot, I suppose, and the rules changed as the Chancellor came and went. Well, that was true up to a point, and particularly in the earlier days, it certainly was. But by about 1785, with Lord Nottingham coming into operation as the Lord Chancellor, we had rules becoming fairly fixed. The rules of precedent began to apply, and we had a fair degree of precedential value in equity as we do at common law. And since that day forward, it's been true that equity doctrines and precedents still apply to bind and to control other courts, or lower courts. Now, if we think about the way in which the courts operate, as I've said, English courts were very, very empirical in the way they developed. No rhyme or reason really about it, pure history. And the courts from early times, as it became more formalised, divided into two broad branches. We had the courts of the king, the king's bench, which was looking at common law claims, dealing with crime, non-assizes, that sort of thing. And we had a court of equity, which was run by the Lord Chancellor and then eventually some Vice Chancellors and some lower judges. And it followed that there was a separate Chancery Bar. The Chancery Bar developed specialist barristers operating purely in equity. And there was a pretty strong division between the two. You wouldn't find men who are experts in wills and trusts going into a court involving arson and murder and that sort of thing. And that Court of Chancery was concerned chiefly with trusts, with settlements, with controlling land, and looking at that sort of operation. Now, procedurally, there was a risk because of the old formalities. If you started in the wrong court, you could have a bit of a problem. There could be a complete disaster in terms of procedure. You might go on for a few years and find suddenly that you'd started in the wrong place, you had to start again. And so for many centuries, as I said, two separate courts, but from 1873/1875, the Judicature Acts were passed, Judicature, in England, which we've copied in Australia, naturally being a colony, former colony, which notionally fused the two jurisdictions. That's to say, we now have one court, the Supreme Court of New South Wales, 1828 Act, which is able to administer all the rules of law and equity. We don't need to worry about which particular court we're in. Only one court. We'll need to look at what that means precisely in terms of practice, but remember, even now, we still have an equity and commercial list or division, and we have a common law division. So although the one judge can give you both remedies, you still need to be careful about where you start. Of course, if you've started off in the wrong division, it's not such a disaster, because now under the rules are much more flexible, of course. Modern times you can transfer from one division to another. But it's still very important to think clearly about what sort of claim you are making. Now, in New South Wales, we've got a funny old historical overlay. In New South Wales, we didn't really get a separate Supreme Court Act in relation to equity and fusion until 1970. Prior to that, we had a separate Equity Act, 1901, which you'll still find if you get out a book like Parker's Equity Jurisprudence in a second-hand bookshop. So there was a separate act, there were separate rules, etc., etc. And this has led to a funny anomaly, I think, in New South Wales particularly, in that for many, many years we have had judges who have been trained up a little bit like the very old English system, where people are trained to think of things purely in equitable terms. And if you think back, we've had some very famous equity judges in New South Wales. And our main book, Mark, Gummo and Lehane, leading world authority really, was written by three New South Wales equity judges. Justice Marr, Court of Appeal, sadly now deceased. Roddy Marr, what a player he was. Justice John Lehane, of course, famous solicitor, and then became a judge of the Federal Court. And Justice W.M.C. Gummo, who's still teaching here and there, Sydney Law School and other places, and is a famous, very famous equity judge. So that has an impact because it means that in our own courts, I think we still have a close affinity with the precise rules of equity. And we'll see that when we look at some English cases in due course. English courts, even though that's the Fons et Origo starting point, they seem to have lost a bit of the old rigour. And I'll tell you what, that's a good thing for us as Australian lawyers, Australian students, because it means when we go away to England, we've still got a very strong underpinning of equity, basic equity rules. And it's important to get those because, although one doesn't like to admit it, a whole lot of business dealings, contracts, banking work, etc. depends on a detailed knowledge of the rules of equity. So if you've got a good New South Wales training, you will be able to go away and work anywhere the law is understood. Right, so as I said, we've got an equity and a commercial division and a common law division. And under the rules, businesses are assigned to each division by rules 1.16 and 45.8 and Schedule 8 in the UCP. And if we look at the way in which matters are divided up, matters involving trusts, wills and estates, companies, partnerships, receivers, they'll be invariably commenced in the equity division. You just know instinctively, once you've done the course, you'll think, it involves a receiver, it involves a company winding up, it involves a partnership. We must start in equity. And there's a difference in procedure there, which we'll just touch on. Well, it's a procedure course, but in equity, we usually start matters by means of a summons. A summons is a short document which sets out the relief you're seeking, the various parties, of course, and then the evidence is put on by way of affidavit. So you don't have any formal pleadings, you've got a summons, and the judges works out what the issues are as we go forward by looking at the affidavits. Common law division, of course, if you've got a negligence, defamation claim, etc., you've got to put on a detailed statement of claim, and that sets out in pretty formal terms precisely what you're pleading and not pleading in a longish document. And when you adduce, in the old days, oral evidence, now perhaps more written statements. But there's a fundamental difference in procedure, and that means that in equity you need to be tried to be fairly precise about what you're looking at in terms of the particular procedure. Now, do common law and equity practitioners have a different mindset? Well, so you might think when you look at the cases that in fact they do. And I say that because the common law and equity have different approaches to things, and it all comes back probably to this notion of conscience. At law you can do various things, and it looks absolutely appropriate and proper as a legal matter. But when you look at it from an equitable point of view, you think, there's something a bit odd about that. Let's take a simple example. Suppose that you have a next door neighbour, and that neighbour's getting very, very old, and you do all sorts of favours for the neighbour. You help the neighbour with the rubbish bins, you look after the cat, you trim the rose hedges, you take in the mail, you might go around and assist in various ways. And that neighbour says to you, look, you've been such a good friend of mine, I am going to give you my house. Oh, well, you think, oh, well, all right, well, am I a blood relation? No. Have you got any? Well, I've got a few children, but they never come and see me. All right, so by deed of gift, Real Property Act transfer, he transfers to you the house. He's not going to last much longer, so he gives you the house. Now, as a matter of law, of course, no problem with that. He's got capacity. He's made a gift to you. The gift is valid. There's been a transfer registered, so a title is passed to you. But, of course, the Court of Equity says, and looks at it closely and says, well, wait a bit, what about a matter of conscience here? How is it that he's ignored all his other relatives who may have some claim of consanguinity or blood on him, and he's given you his house? What's going on? Did you influence him? Did you make use of your relationship with him? Did you overbear him? Was he advised to get advice independently? How did it all happen? Now you can see there two completely different approaches. Court of Equity says there's something a bit odd about this. Court of Common Law, well, there's nothing at all, nothing odd about it. If you want to look at a funny case on that, a great case to read Brocklehurst's estate, 1978, Chancery 14. In that case, Lord Denning, who's a famous Chancery and Equity judge, of course, says that a gift has to be set aside. It's a funny old case. The man owns a huge estate, very rich. He's a baron. He's also a former senior officer in the British Army. And he's got a naval rating who comes and does various things to help him. And the naval rating, he's a garage proprietor. He always comes to the back door of the big house and he helps him out in a very English sort of way, English class structure. And then he says to the fellow, what would you like, what can I do for you? And he says, well, I got a shooting. So he gives him, that's the older man, gives him the right to shoot over the entire estate, which of course has a tremendous impact on the value of the estate, because you might have a gun or anything else being operated under your back window. And someone says to him, his neighbour says, well, what are you doing? Are you sure you're doing this? And he says, couldn't care less. I've only got a couple of relatives and they don't care about me. So this nice bloke's looking after me, I'm going to help him. So of course he dies. He's gone to earth, as he says about the fox. He's dead, and it all comes out. And the two, and of course the relatives complain and say, what the heck has happened? You've given away a very valuable asset. Well, Lord Denning says, yes. This doesn't look too good. There's an older man here. There's a question of conscience. There's a gift. There's a question of not impropriety, but undue influence, etc., etc. So legal gift, but in equity, no good. But of course he's sitting in English Court of Appeal. He's got two common law judges sitting with him. And the common law judges look at it. I think it's Lord Justice Bridge. And Lord Justice Bridge says, well, what's the complaint? All what happens was a former commander, a colonel of the Life Guards or the Arab Legion or whatever the regiment was, he simply tells a naval rating to do something and he does it. End of story. So in that case you can see, because of the split on the court, 2-1, two common law judges versus Lord Denning, the gift is upheld. Now that's just an old example I've always liked to look at. I like to reread that case. It's a fascinating story as well, written by Lord Denning, and the main judgment is fascinating. But that illustrates an equitable mindset. So that's what you've got to think about. Now, we've got the notion, of course, of New South Wales. I've said, what's happening in New South Wales? New South Wales, we've still got a notion of a split between law and equity. And I've got various quotes you'll see on the PDF. And I suppose looking all the way back, we've got Frederick William Maitland, the most famous equity writer. Equity, a good book to look at. You can get it in a bookshop, not too cheap, or get it online. He died the beginning of the century, beginning of the 1900s. He caught tuberculosis while he was teaching. He died unfortunately at Cambridge, but he said this famously. He said, "A day will come when lawyers will cease to inquire whether a given rule be a rule of equity or a rule of common law. Suffice it that it is a well-established rule administered by the High Court of Justice." So he's saying, well, we've got a complete fusion in a sense. Rules of equity and law overlap, no problems. But then we've got Justice McHugh and Pelachowski and Registrar Court of Appeal. Transcript, I've given you a quote. He says, "That is true, but just answering what Justice Kirby said in 1970 and thereabouts, these questions of exclusive jurisdiction and divided jurisdiction between common law and equity were the daily diet of practitioners in New South Wales." A daily diet. In other words, if you're practicing in 1970, you had to know all the distinctions that could be drawn in the system. And then we've got Justice Gummo, a great equity judge in Road Transport Authority and Dederer, D-E-D-E-R-E-R, 2007, High Court of Australia 42 at paragraph 57. And he's looking there at a common law claim in terms of negligence. And he says this: "What is demonstrated here is a byproduct of the common law technique, which looks to precedent and operates analogically as a means of accommodating certainty and flexibility in the law." Right, so you're looking at an analogy and precedent. He then says this: "Equity, by contrast, involves the application of doctrines themselves sufficiently comprehensive to meet novel cases. The question of the plaintiff, what is your equity, thus has no common law counterpart." He's right about that. In the equity division, the judge might say, what is your equity? In other words, upon what general equitable basis or doctrine are you able to obtain relief? You don't ask that at common law. You simply say, these are the facts, give me my remedy as of right. What is your equity? Good question. And then we've got Professor Lasky quoting Sir George Jessel. "No one can understand equity before they are 40. That's his famous comment. Is that true? Well, not so sure about that. What he's really saying is that equity is hard to follow, and equity depends upon drawing together a large number of influences, I suppose, and life experiences. All right, so to summarise, we're looking at something in terms of equity which is discretionary. It's acting in personam. It's acting by way of a direct order against the defendant. It's acting on historical bases where we're looking at a broad doctrine sufficient to meet novel cases. Now, we've got various jurisdictions in equity. We've got the exclusive jurisdiction, we've got an auxiliary jurisdiction and a concurrent jurisdiction. What is the exclusive jurisdiction? Well, the exclusive jurisdiction looks at the enforcement of equitable claims which can be looked at or are cognisable only in equity. For example, the rights and duties of a trustee and the rights and duties of a receiver. A trustee claim can't be brought in the common law division. You can't sue a trustee, broadly speaking, for negligence. The Court of Equity will look at whether there's been a breach of trust and the trustee has misconducted himself or herself. Similarly with a receiver. So that's something that's in the exclusive jurisdiction of the court. The auxiliary jurisdiction, as the name suggests, is concerned with intervention by the Court of Equity by way of injunction or otherwise to assist in the enforcement of common law rights. So, for example, by way of breach of contract, and for perhaps an injunction to restrain an implied negative stipulation. Remember, in contract law that there might be something which gives you a negative stipulation, a negative implication. You promise to do X and therefore you promise to not do Y and Z. You're only going to do X. Can equity give you an injunction to stop someone else not doing X but rather trying to do Y and Z? That's a bit technical, I suppose, isn't it? Let's think of an easy example. A good example is when you give an undertaking or a promise in a contract of employment to work for someone. I'm just going to work for you, not going to work for anyone else. And of course, a lot of high-flying businesses, if you're on television or you're a big stockbroker, they will try and keep you to your job. They don't want you running off. Can you then say, no, blow you, I'm off? Well, the Court of Contract, the Court of Common Law would say, well, breach of contract, damages, I suppose, but off you go, freedom of contract. Court of Equity says, well, there's an implied negative stipulation there. You have promised only to work for X for 6 months. We will stop you for working for Y. And you often see this on the television. Some famous stars on television, he or she go to a new channel, Channel 7, Channel 9, Channel 10. channel 2, I suppose, then you intervene to stop them doing that. Well, that's the sort of auxiliary jurisdiction. Equity is aiding the common law. It's offering an injunction when there's a common law breach. And then finally, we've got what's called the concurrent jurisdiction. That's the availability of a claim in law and equity. So, for example, you might be able to get a specific performance of a contract for the sale of land, or you might be able to get damages for the breach of contract. You've got a concurrent possible claim. So those three possibilities: exclusive jurisdiction, auxiliary jurisdiction, concurrent jurisdiction. And it's worthwhile to look at the various examples of that, and just to be aware of that fundamental way in which we divide up the jurisdiction.